Contracts. A contract is an agreement between two or more parties to do, or not to do, something. Contracts are legally enforceable promises, with the law providing remedies should either party breach the terms of the contract. As a real estate professional, you will be required to handle and understand various real estate contracts, since many disputes in a real estate transaction can be tied back to contracts. An understanding of basic contract law is important. In this review, we'll discuss how contracts may be classified, the status of contracts, and the requirements to form a valid contract. We'll also examine the most common types of contracts that you'll encounter as a real estate professional: a purchase agreement, which is negotiated between an owner of property and a potential buyer, and a lease, which is negotiated between a landlord and tenant establishing the terms of the tenancy. A contract can be expressed in words, either oral or written, or implied by actions of the parties. In a bilateral contract, each party makes a binding promise to the other, a promise for a promise. With a unilateral contract, one party makes a binding promise to another party as a way to induce the second party to act in some way. An executory contract is one in which one or both parties have not yet performed their contractual obligations, though they may be in the process of carrying out their duties. An executed contract is one in which both parties have fully performed their contractual obligations. A valid contract is a binding, legally enforceable agreement that meets all of the legal requirements for contract formation. A void contract lacks one or more of the requirements for contract formation or is otherwise defective. A voidable contract can be terminated or nullified by one party without liability because of a lack of legal capacity, fraud, or duress. An unenforceable contract may have been valid between the parties, but a court would refuse to enforce it. For a contract to be valid and enforceable, it must have these essential elements: mutual agreement, contractual capacity or legal ability, lawful and possible objective, and consideration. When an adult enters into a contract with a minor, the contract is voidable by the minor only. Even if the minor claimed to be over age 18, the minor can disaffirm the contract at any time before turning 18 or within a reasonable time thereafter. The minor may choose to enforce the contract and require the adult to perform. The adult does not have the power to disaffirm the If a person has been declared incompetent by a court because of mental illness, intellectual or mental disability, or senility, any contract into which they enter is considered void and unenforceable by either party. To be enforceable, the contract would have to be signed by the incompetent person's court-appointed guardian or someone who has been given power of attorney. Even if a court has not declared someone to be legally incompetent, if it can be proven they were not of sound mind when the contract was signed, the contract may still be voidable by that person. If a party obtains another's consent through fraud, undue influence, duress, or mistake, the contract is voidable by the victim. Remember that each state has a statute of frauds that requires certain contracts to be in writing and signed to be enforceable. This includes contracts concerning interests in real property such as purchase agreements, options, powers of attorney, and brokerage agreements that stipulate payment of commission. A power of attorney is an instrument authorizing one person, called an attorney in fact, to act as another's agent to the extent stated in the document giving the power of attorney. The Uniform Electronic Transactions Act provides a legal framework for the use of electronic signatures and records in government or business transactions, making them legally equivalent to paper contracts and manually signed signatures. Now let's discuss the mutual agreement requirement in more detail. Mutual agreement, sometimes referred to as a meeting of the minds, is achieved through offer and acceptance. An offer occurs when one party, called the offerer, proposes a contract to another party, called the offeree. An offer must meet some basic requirements. First, acceptance can be made only by the offeree. It must be clearly communicated to the offerer and it must be made in the manner specified. Finally, it must not vary the terms of the offer or otherwise impose conditions. To create a binding contract, an offer must be accepted before it expires. An offer terminates if the offerer revokes or withdraws it before the offeree accepts it, if the offeree rejects the offer, or if one of the parties dies or becomes incapacitated. An offer would also terminate if the improvements that are the subject of the offer are destroyed. A counter-offer represents a change to some of the terms of the original offer. It is, therefore, a rejection and a new offerer. The original offerer has become the offeree, and the original offeree is now the offerer. The process of negotiation continues until both the buyer and the seller agree to all terms and a meeting of the minds occurs. Remember that a licensee has a fiduciary duty to disclose to a seller client all offers to purchase. Even if an offer seems unacceptable or if its acceptance would mean a smaller commission, the seller, not the agent, decides if an offer is acceptable. Genuine assent means that the parties involved in creating a contract are giving their consent freely. Offer and acceptance as an expression of genuine assent is not freely given in the case of fraud, undue influence, duress, or mistake. A contract is discharged when it is, in some way, terminated. Ideally, a contract is discharged by full performance, which occurs when all the terms of the contract have been carried out. A contract can also be discharged through a mutual agreement to rescind, partial performance, impossibility of performance, and abandonment. Rescission means that both parties mutually agree to rescind or terminate all contractual obligations and return any consideration to the other party. That return of consideration is known as restitution. Conditions, also called contingency clauses, are contract provisions that make the parties' rights or obligations dependent on the occurrence or non-occurrence of certain events. A contingency allows a party to terminate a contract legally without liability. A breach of contract occurs when one party to a contract fails to perform with no legal cause. The breach does not terminate the obligations of the breaching party. A breach is material if it is important enough to excuse the non-breaching party from performing any contractual obligations. For example, many contracts state time is of the essence. The purpose of this phrase is to emphasize timely performance as an essential part of the contract. Failure to perform on time is a material breach. If one party to a contract performs badly or refuses to perform, the injured party could take legal action. The most legal common remedy for breach of contract is compensatory damages. A liquidated damages provision in a contract indicates how much one party will collect if there's a breach. Specific performance is a court order requiring a breaching party to perform the obligations under the terms of a contract. This remedy is usually available only when the contract involves unique goods, such as real property. Sometimes the parties to a contract may agree to alternative solutions to avoid terminating a contract. In an assignment, one of the parties transfers rights or interests under a contract to another person. Novation is the substitution of a new contract for an earlier contract. The new contract cancels the original contract, relieving the original party of liability. A signed purchase agreement is the conclusion of what can be a long process of listing, marketing, and showing property, followed by the back and forth of negotiation. Purchase agreements are contracts in which a seller promises to convey title to real property to a buyer in exchange for the purchase price. In some areas, these may be called purchase contracts, sale contracts, earnest money agreements, and other similar terms. Whatever the name, a real estate licensee should be familiar with the standard provisions and contingencies. Recall that the execution of a valid purchase agreement conveys equitable title to the buyer. Equitable title is a limited ownership interest in property created on the execution of a valid purchase agreement. Actual legal title will be transferred by deed at a future date, generally at the closing upon full performance of the contract. In most states, a local real estate board or state real estate commission offers standardized pre-printed purchase agreements. These templates contain all of the information necessary to create a legally binding purchase agreement. Licensees can assist their clients only by filling in the blanks with specific data. In most states, drafting a purchase agreement is considered to be the practice of law and can be performed only by an attorney. A purchase agreement must state all terms of the sale as clearly as possible. It must identify the parties to the contract, in other words, the buyer and seller, and the property to be transferred. The purchase agreement must also identify the interest in the property to be sold, any personal property that is included in the sale, the total purchase price and method of payment, and critical dates related to the contract, such as those for clearing contingencies, closing dates, or possession dates. In most states, purchase agreements must be in writing and must be signed by all owners of the property to be enforceable under the statute of frauds. In some markets, or for certain types of transactions, a document called a binder is used instead of a standardized purchase agreement. A binder, also called a letter of intent, serves as a roadmap for the creation of a purchase agreement. Despite its name, a binder is not legally binding. If all parties agree to the terms in the binder, it is usually the seller's attorney who drafts the actual purchase agreement. Notice that earnest money was not included in the list of elements necessary to form a valid purchase agreement. Earnest money is a pledge from a prospective buyer to show they are serious, but it is not required. In many purchase agreements, the earnest money deposit is pledged as liquidated damages to be paid to the seller if the buyer defaults without legal cause. Purchase agreements generally include contingencies, for example, financing and inspections. As mentioned earlier, a contingency is a way for either party to get out of the contract due to a specified circumstance or condition. If the condition is not met, the party can withdraw without liability for breach of contract. Note that if the buyer cannot get financing and the contract does not include a financing contingency, the buyer is still obligated to buy the property, whether they can afford it or not. Also, remember that an as-is clause in a contract does not relieve the seller or listing agent of the obligation to disclose known material defects about the property. As mentioned earlier, a time is of the essence clause requires all parties to the contract to meet all deadlines. Failure by either party is a breach of contract. A purchase agreement is an example of a bilateral contract. Both buyer and seller make a binding promise to perform. Now let's discuss two types of unilateral contracts. An option is a contract in which one party, called the optioner, gives another party, called the optionee, the right to buy or lease their property at a specified price within a limited time, but without the obligation to do so. Like all contracts, an option must be supported by consideration to be enforceable. Once paid, the option money is not refundable, regardless of whether the optionee proceeds with the purchase. If the optionee chooses not to exercise the option, the optioner can keep the money as compensation for keeping the property off the market during the option period. In many cases, if the purchase goes through, the option money is credited toward the purchase price, much like earnest money in a purchase agreement. Another unilateral real estate contract is called a right of first refusal. This gives someone the first opportunity to buy a property if the owner decides to sell it. This right of first refusal cannot be exercised until the owner gets a bona fide offer from a third party. At that point, the owner must make the property available to the one holding the right of first refusal at the same terms as the bona fide offer from the outside party. The real estate contracts we've just discussed transfer title in real property from seller to buyer, which gives the buyer the full rights of ownership, including possession, quiet enjoyment, disposal, exclusion, and control. Next, we'll discuss leases. A lease temporarily transfers the right of possession of property from the owner to another person without transferring title to the property. The owner-landlord is called the lessor, and the tenant is called the lessee. The landlord still owns the property, and the tenant has only a leasehold estate. The landlord retains the right to get the property back at the end of the lease. It is, therefore, a reversionary interest. Since the lease is a contract, the four essential elements of a valid contract are also necessary. For a valid lease, the landlord and tenant must have the legal capacity to contract, which means they cannot be incompetent or under the age of 18. There must an offer and acceptance. The lease must be for a lawful and possible objective. And there must be consideration, which usually is the rent in exchange for possession of the property. It's important to note that a security deposit is not consideration and is not a requirement for a valid lease. It helps the landlord ensure compliance with the lease terms and may be withheld if necessary to repair damages beyond normal wear and tear. Residential leases tend to be straightforward exchanges of rent for occupancy, and generally are gross leases. With a gross lease, the tenant pays a fixed rent, while the owner or landlord pays all ownership expenses, such as property taxes, mortgage payments, repairs, insurance, and sometimes utilities. Typical residential leases generally address house rules and tenant conduct, including policies addressing pets, smoking, noise, etc. Commercial leases tend to have more options and are often more complicated. Commercial leases are often net leases. With a net lease, the tenant pays some or all of the ownership expenses associated with the property, property taxes, insurance, and maintenance and operating expenses, in addition to rent. If the lease requires the tenant to pay one of these expenses, it's called a single net lease. If the tenant is required to pay any two of these expenses, it's a net lease, or a double net lease. A triple net, or net lease, requires the tenant to pay all of these expenses. A percentage lease is used for retail space. A retail tenant pays a base rent, and then overage rent, which is a percentage of gross sales over and above a certain breakpoint. A land lease, also known as a ground lease, allows the tenant to lease just land on a long-term basis. A land lease typically includes a provision that allows the tenant to construct a building on the property that the tenant will own upon completion. A common guarantee in a lease is the covenant of quiet enjoyment. It protects the tenant from interruptions by the property owner without the tenant's consent. Property owners must provide Reasonable notice to tenants before they, or contractors they have employed, enter the premises. The owner does have the right to enter the premises in an emergency to protect the Remember that the sale of leased property does not automatically terminate the lease. When a new owner takes title subject to a lease, the tenant remains with the property and all former owner's rights and duties under the lease are transferred to the new owner. Tenants may have options to transfer their rights under a lease. Assignment transfers a tenant's entire interest to another party. The assignee, the second tenant, has primary liability, and the assigner, the original tenant, has secondary liability for paying rent to the landlord. Sublease transfers a tenant's right of possession to another person for part of the lease term. It does not alter the legal relationship between a landlord and the original tenant, who has full legal responsibility for paying the landlord. Many leases contain a clause requiring the landlord's consent for an assignment or sublease. That concludes this review on contracts. We discussed the ways that contracts can be classified and the essential elements for a valid and enforceable contract. We also discussed the important process of offer and acceptance and saw how a contract may be discharged. Finally, we reviewed various types of contracts that are used to transfer all or part of a property owner's interest in real property.